Hello, my name is Richard Goldstein. I'm a partner in the pensions group at Mayer Brown. Welcome to the second episode of our new monthly video series. In these videos, we will cover different topics each month, providing an overview of the issues faced by pensions industry practitioners and offering some practical insight. Time spent watching these videos can count towards solicitors and PMI CPD requirements. Please contact us if you require further information. Contact information will be provided at the end of the video, and all videos are available on our Mayer Brown YouTube channel. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. In this episode, I'm going to talk about new requirements that will come into force this December for trustees and service providers in relation to the use of investment consultancy and fiduciary management services. In September 2017, the Competition and Markets Authority, or CMA, launched a market investigation into investment consultancy and fiduciary management services provided to institutional investors, focusing on pension scheme trustees as the main customer group in the investment consultancy and fiduciary management markets. The CMA published its final decision report, setting out its findings and proposed remedies in December 2018. It has now published an order imposing these remedies together with an explanatory note. The order imposes remedies on both trustees and providers of investment consultancy and fiduciary management services. When appointing or reappointing a fiduciary manager in respect to 20% or more of scheme assets, trustees will be required to run a competitive tender process involving at least 3 managers that are independent of one another. Trustees will be required to provide written confirmation to the successful manager that their appointment was as a result of a competitive tender process. Fiduciary managers will be prohibited from accepting a mandate where there is a requirement to run a competitive process unless the trustees provide this confirmation to them. Looking at investment consultants, trustees will be required to set strategic objectives for their investment consultants. These objectives must relate to the advice provided by the consultant to the extent that the advice covers one or more of the following. 1. The investments that can be made or held by or on behalf of the trustees. 2. Any matters on which the trustees are required by law to seek advice in relation to the preparation or revision of the scheme's statement of investment principles. 3. Strategic asset allocation. And 4. Manager selection. The CMA expects the objectives to be reviewed at least every 3 years and after any significant change to the scheme's investment strategy. Investment consultants will be required to separate documents marketing their fiduciary management services from their investment advice documents. They will also be required to include prescribed text in such marketing documents, identifying the documents as marketing materials and reminding trustees of their duty to tender competitively for fiduciary management services in certain cases. Fiduciary managers will be required to provide better information on fees for existing and potential customers to enhance the ability of trustees to assess value for money. Fiduciary managers will also be required to develop and use a standardised methodology and template for reporting past investment performance to prospective customers so that trustees are better placed to assess the quality of alternative fiduciary managers. Investment consultants and fiduciary managers will also be required to report performance of any recommended asset management products or funds using basic minimum standards to enable trustees to compare performance better. The new requirements will take effect on 10th December 2019. Trustees and service providers will be required to submit annual compliance statements to the CMA confirming the extent to which they have complied with the requirements. The CMA will initially monitor compliance and enforcement of the remedies. However, the government is currently consulting on new draft regulations which, 1. Integrate the remedies that apply to trustees into existing pensions law, and 2. Enable the pensions regulator to monitor and enforce compliance with those remedies. These regulations replicate the CMA's remedies order, subject to some minor differences. In particular, rather than submitting annual compliance reports to the CMA, trustees will be required to include details of their compliance with the regulations in their scheme returns. This consultation closes on the 2nd of September 2019, and the regulations are expected to come into force on 6th of April 2020. Trustees will need to comply with the requirements of the CMA remedies order between 10th December 2019 and the date on which these regulations come into force. The pensions regulator is also consulting on guidance to support trustees in compliance with these new remedies. This guidance covers tendering for fiduciary management and investment consultancy services, setting objectives for investment consultants, and choosing an investment governance model. That consultation closes on the 11th of September 2019. The Financial Conduct Authority will be responsible for imposing replacement requirements on investment consultants and fiduciary managers, and for monitoring and enforcing compliance with these requirements. That ends this episode. Please feel free to email me with any comments or questions on this episode to rgoldstein@mayorbrown.com. That's rgoldstein@mayorbrown.com. This episode is an overview of the law in this area, and how the law applies in any particular case will depend on individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.